Good evening, ladies and gentlemen. Thank you for persevering through the snow. Back to CIBC Presents Entrepreneurship 101. I am truly delighted to welcome tonight's speaker, Arshia Tabrizi. Arshia is a true friend of Mars. He participates in a number of ways with Mars, working with our companies and so forth. But what's most important to me is he spent an hour and a half on the road getting from North Toronto in order to come down to present what is, I guess, the third time at least in giving this lecture. I'll pull Arshia's leg a bit and say his story is a sad one. He started out as a computer engineer, an honest engineer scientist, and he worked at at IBM. I'm just trying to find it in his background. Yeah, he was a software developer at IBM. He spent a summer as an NSERC research associate at the U of T Bell Optoelectronics Lab, and then he fell off the straight and narrow and went into law. And it's in that context that he is here. He practiced in California in the Valley, and those of you who know the high-tech community in the Valley will recognize the name of Wilson Sonsini Goodrich and Rosati. So he practiced there before coming back to Toronto, and he is the principal and founding partner of the Tabrizi Law Office. Arshia specializes in working with startup, emerging companies, and in interfacing them with the angel community and the VC investment community. And as I say, I know personally a number of the small companies that have come into Mars for advice, who Arshia has shepherded through the process of getting financing and growing to become successful companies. So we have asked Arshia to come and to talk about intellectual property, but as a business tool, because that's the space where he plays, and I think that's what's most important for you folks to hear about. So without any further ado, Arshia.
Thanks, Tony. Did you want to talk about your Upstart thing? Sure. Do you want to do it? Okay. All right. Okay, so this is on? Everybody hear me? Okay. So let me see. All right. So thank you, Tony, for the introduction. So this is the third year I'm doing this talk, so hopefully none of you guys was here last year, because pretty much doing the same talk I did last year on intellectual property strategy. So before I start, I'll start with my lawyer jokes. I like to crack a joke at ourselves. I'll just put that up there. For those of you who can't read that, the boy on the slide is telling the other guy, "Oh yeah, well my dad will sue your dad for beating him up." So, but I think the good thing nowadays is that there are probably two other target groups which have been more highly targeted for jokes than even lawyers. So I'm going to start with a broker joke. And this is a question they asked the one guy who didn't lose any money with the market collapse. So they asked him, what is the secret of your investing success? He says, I just do the opposite of what my broker tells me to do. So hopefully, I don't know if you guys did, maybe for the next time you talk to your broker. And my final Bush joke, I know he's out of office, but I thought this one was hilarious. This is about the Lehman Brothers. So he said that he was really sad to hear about Lehman Brothers and that his thoughts go out to their mother because losing one son is hard enough, but losing two is a real tragedy. Oh well, we're going to miss him, aren't we? Okay, so I'll start with a little just background on what we do. Basically, we practice business, IP, and technology law. We have a newsletter on legal issues for startups and tech companies, and if you want to sign up, you can send an email to that address over there. So we basically do the full scope of corporate work for startups, incorporating setting up the company, doing stock options, shareholder agreements, and as Tony mentioned, helping startups go through the venture financing process. Intellectual property, we do trademarks as well as a general litigation and advice on IP. My own practice, half of it is focused on technology transactions. So licensing, distribution, partnership agreements between tech companies. And we, of course, do some internet law as well. Before we even get started, I guess the question I want to pose is, why should you even care about IP? And I think before answering that, the question is, well, first of all, what is your business? What business are you in? And for most of you, you are or will be essentially in the business of innovation. And what do you have to start as a startup company is basically you have an idea. And an idea or some process or some technology that you've come up with. And basically intellectual property is about protecting and exploiting that intangible asset or that idea. So essentially, the reason you care about IP is because IP is what your business is about. So really the question is, how do I IP my ideas? That's what we're trying to address today here in the lecture. Well, the first thing is, as a general piece of advice, don't share your ideas with the entire world. So if you come to Mars for advice, that's fine. You can talk to Tony, but don't go out posting in blogs, say I have this great idea, okay? Or sending out your business plan to everybody on your email list. Talk to a qualified lawyer. It's really important that you get legal advice early in the process of starting your company. Finally, pay attention to this lecture. I know you've all come a long way, but don't fall asleep on me. I know it's getting late. Hopefully you can pick up some pieces of advice that will be useful to you. So what are you going to learn today? First, we're going to talk about basically what is IP. So we'll talk about different forms or categories of intellectual property. And then for each category of intellectual property that we talk about, we're going to explain how do you get or how do you obtain that IP. Once you've obtained that IP, how do you keep the IP? And then as Tony said, and that's kind of my approach to intellectual property, because I have more of a transactional background, is how do you use that intellectual property in your business? And finally, as we go through different kinds of IP, I want to give you a sense of the pros and cons of each IP. And so I guess the point I want you to take away there is that IP is not 100% good. Each form of IP also has some downsides to it. So you want to go through that as you think about what form of IP you want to pursue for your particular ideas. Oh, sorry about that. So let's start with the first form of IP, trade secrets. So first question, obviously, what is a trade secret? And this is perhaps the simplest form of IP because the answer is in the name itself. So in other words, a trade secret is, a trade secret. So something that you keep secret. This can be anything from a formula, a program, can be a device, a process, any kind of technology could be covered by trade secret protection. But more importantly, business information as well. So when I mentioned before, don't share your ideas, I wasn't only talking necessarily about your technology, but also about perhaps a business process or your business plan. In some cases, certain startups, for example, think about the internet space. Most companies in the internet space are not really coming up with extremely innovative technologies per se. What they're doing is they're coming up with interesting business models and then succeeding in getting that idea to market first. So then it becomes very important that your business plan is also part of your IP, and so treat it as such. And then, of course, things like, as you evolve through your business cycle, the names of your strategic partners, names of vendors or customers that you might have. Those are also potential trade secrets that might be distinguishing you or giving you a competitive advantage vis-a-vis other companies. So you want to, again, treat those as secret and valuable information. So now that we know what a trade secret is, well, how do you get a trade secret? Now, and this kind of sounds like self-evident, but first of all, don't steal it, okay? So what I mean by that is a trade secret is something that has to originate from you. So if you're working with a company you come across their customer lists or information such as that, and you decide to take that over and start your own business with that information, obviously that's not a good way to obtain trade secret information. So that's really the in terms of how do you obtain trade secrets. There's no real test. There's no ingenuity that you have to apply. But there are some issues to consider in terms of how do you keep something a trade secret. Again, kind of self-evident, keep it secret. But the point here is, obviously from a business or a practical standpoint, you're all going to say, well, yeah, obviously if it's something is valuable to me, I'm going to keep it secret. But I think what's important from a legal standpoint is that by actually disclosing something broadly, and if that information loses its quality of secrecy, then under the law, basically you might lose whatever legal protection you might have had for that. So it's very difficult to say that something is a trade secret and that it's very valuable when you post it on your website. So you can't say, for example, my customer list is a trade secret, my employee stole it when he left the company, where anybody who goes to About Us on your website sees the entire customer list. Secondly, NDA it. And by that I'm NDA, and I'm sure most of you are familiar with that acronym, non-disclosure agreement or confidentiality agreement. Make sure that if you are disclosing trade secrets to potential partners or investors or people you may want to bring on as employees or contractors to join you in the company, make sure you ask them to sign a proper non-disclosure agreement. And again, the important thing there is that the law looks at what efforts you are expending in order to maintain the secrecy of this type of information. And then from more practical standpoint, secure it. So depending on the sensitivity of the information, keep a limited number of copies, let's say, of your customer list. Put password protection on particular pieces of information. And again, from a legal standpoint, that is important because if you go, again, in a court of law, and let's say, going back to that first scenario, you have an employee and you say this employee has misappropriated this information, then you have to show, well, what security measures did you take in your work area or in your office to indicate that this thing was supposed to be treated as very sensitive information? Did you put security measures on that? Was it reasonable for the employee to think that this stuff was highly sensitive information? And along those lines, market is confidential. So when you pass around your business plan, put a little notice on it, confidential ABC Co. How do you use trade secrets? Well, as I mentioned, for example, in the internet space, or I guess in any other business where speed to market is important, then it can be valuable to kind of operate in what we call stealth mode. So, and you'll see some of these companies which you hear about them and you go on their site and for months all you see is like we're in stealth mode, information coming soon. So you don't even really know what this company's business is, what they intend to do. And basically, operating in stealth mode, or even further down again your business cycle, you're essentially what you're doing is you're keeping your competitors in the dark as to your secret sauce, right, for your business. The other thing, I guess, that people don't think about in terms of how you can use trade secrets is really as a tool to obtain information as well. And what I mean is the nature of the technology industry in general whether you're operating in biotech or the internet space or software or hardware, is that you're highly reliant on partnerships and alliances, whether it be with people who are going to contribute a piece of technology that fits in with yours, or somebody's going to help you distribute your technology or provide funding for your company. And even in the very early stages of your business, you can use the fact that you have this trade secret that you're going to give some valuable information to them to obtain valuable information back from them. So as a small company, what you have to share is technology and your business model, but you could get into discussions with a larger company who might have much more information about the market or about the sales channels and distribution strategies. And through executing a mutual NDA, have some sort of a discussion, and through that, you have this exchange of information. Getting funding, of course, it's important, and Tony will attest to this. Most, if not all, institutional VCs will refuse to sign non-disclosure agreements, and the argument being that basically the reputational market already protects you, because if any VC misappropriated your information and that leaked out, then nobody else would be willing to disclose their business plans to them. And of course, the volume of information that they see makes it somewhat risky for them to sign NDAs with every single company, because it is in fact highly likely that they will see other companies in the general space that you're talking about. So they want to be careful that they're not putting themselves in a position to have to be facing all these lawsuits because they happen to look at business plans from various companies. But the flip side is, as I always tell people, those same VCs want to make sure that you've signed NDAs with every other potential party that you've ever disclosed information to. So, but the reality of the market is that they will most likely not sign NDAs. Finally, in terms of licensing, again, and we'll see this with all forms of intellectual property, and with trade secrets as well. Whatever secret sauce or technology you might have, well, it can be used not only internally, but also you could license this. In other words, you could enter into an agreement and share it with another party who would use that information in their own business, and you could obtain revenues for your company through that. Franchise it, and there really my thinking was, when I put that bullet in there, is if you think about the restaurant business, in the pizzas and the McDonald's of the world, well, they are really in essence franchising trade secrets. They're franchising a proprietary business model, right? Not necessarily technology, but ways to operate a fast food restaurant and make it efficient, and et cetera, et cetera. So, trade secrets can be used in a whole variety of ways in commercial ventures. So, what are some of the pros and cons of trade secrets? Well, the biggest pro is that there is really no time limit on a trade secret. So, in terms of intellectual property law, as long as you keep that piece of information secret, it will have value. And so if you look at something like the Coca-Cola recipe or the Coca-Cola formula, well, it's been around for decades, and it's still a secret sauce, right? And a big part of their business, their entire business is kind of built on that secret sauce. Some of the cons, and what I mean by that is once going back again to how do you keep a trade secret such, you have to keep it a secret. So if at any point you inadvertently or somebody else who you've disclosed this information inadvertently discloses and makes it publicly available, then you're out of luck, and essentially your IP's out there, and the law is not necessarily going to protect you once it's publicly available. So that's one of the downsides of trade secret protection. Reverse engineering, so to the extent that anybody can, so if you have some proprietary process that you're using in a microchip, if somebody can take the microchip and reverse engineer it and arrive at the same process, again, you're out of luck. There's no remedy at law for you on a trade secret basis to go after person and say, well, this is my process. So it doesn't protect you against reverse engineering. Enforcement, it's very difficult to prove trade secret infringement, particularly when you get into complex areas of technology. It's very difficult to connect the dots. So for example, we're in a situation now where one of my clients did license some IP, which was trade secret IP, to a chip company. And the senior engineer who worked at that chip company A, is now working for chip company B. And my client is absolutely sure that this individual has misappropriated his trade secrets, and basically company B is now implementing similar algorithms in their chips. But this is only because this person was exposed to this trade secret information when he was working at company A. Now, in order to actually establish that that is the fact, that this information was not available to them through any other sources, is very difficult. So enforcement is really one of the key problems with trade secret protection. And then, of course, patents. And we'll talk about patents a little bit later, but suffice it to say, if somebody comes ahead and patents the same thing that you had as a trade secret, then you're out of luck, right? Because that grants them a monopoly. So there's always a danger there. So let's talk about the second form. Oops, sorry, keep pressing the wrong button. So let's talk about patents now. What is a patent? A patent is basically an invention, but it's an invention that has to meet certain legal hurdles, okay? It's got to be new, so nobody else should have come up with it before. It's got to be not obvious, and what that means is even if it's new, that somebody else who is familiar with that particular area of technology would not have easily come up with the same invention. So there's got to be a little bit of an inventiveness step there, and it's got to have utility. In other words, it's got to have some commercial utility. The types of things that you can patent a product, process, a machine, composition of matter. As some famous judge said centuries ago, is anything under the sun can be patented. Now we'll see that that's not necessarily the case, but really it is a pretty broad area of IP. Now, what's important to note is that a patent is not an idea per se. Now, this is kind of where things get a little bit into a gray zone, because when you go to a patent agent and you come up with some neat technology, let's say, or some neat idea that you have, what the patent agent is going to try and help you do in the scope of the claims, or essentially in terms of claiming the scope of what this patent is going to protect, they're going to try and actually protect the idea itself. So while technically under the law, a patent is not supposed to be over an idea, in fact, a lot of times patents do end up covering an idea. But the second point that I wanted to make relating to a patent not being an idea is that a lot of times you'll see people come and they'll come to me and they'll say, I had this idea that, maybe you can have a plane that can also, operate as a car. Okay, so it can convert from a plane to a car. And it's like, okay, so that's a great, can I patent that? It's like, well, did you just dream this up and now, this morning you want to patent it? You have to take some steps towards actually arriving at an actual invention or an actual product or an actual process. You can't just go in and say, hey, I want to, patent this idea. Related to that, you can't patent a mathematical formula. So Einstein could not have patented E equals mc squared. And part of where all these limitations come from is that really, patents are essentially government enforced monopolies. So there is a public policy behind what a patent is supposed to do and not do. So from a public policy standpoint, patent legislation doesn't want a pure mathematical formula to be owned by somebody essentially as a monopoly. And in Canada at least, and not so in the States, but in Canada at least, you can't patent a method of medical treatment. So surgeons who come up with neat medical treatment processes can't get a patent on that in Canada. So how do you obtain a patent, assuming you've come up with an invention that you think is patent worthy? Well, the first thing is either yourself or through a patent agent or a patent lawyer, you will search the patent registry. Now, when I say patent registry, keep in mind patents are territorial. So you got to look at the patent registry in Canada, you got to look at the patent registry in the States, and in different markets. So in most cases in Canada, if you're looking to establish a business here, given that 80% of our exports to the US, and that's in most cases our primary market, you would want your patent agent at least to do a search in the US patent registry and not just the Canadian patent registry. And assuming the patent agent says, okay, we've done a search, and there are no other patents, and we think that you have a good shot and that essentially your invention is patentable, then you go ahead and you prepare an application. The application itself consists of two parts. The disclosure, which basically describes what the invention is. And the idea there is that somebody who's familiar with that area of technology should be able, by looking at the disclosure of the invention, to recreate the invention or to practice the invention. So there's got to be sufficient details there. And then perhaps more importantly is the claim section of the patent. And that's where you'll get into very technical language, and that's why you really want to make sure that you have somebody who is qualified as a patent agent. For example, if you're filing in the States, you want to make sure that if your patent agent here in Canada is filing for you in the States as well, that they are either a US patent agent or they have a US patent agent in the States who's going to review the application and make it comply with US standards in terms of the claims language. So the claim basically is what the scope of your invention is. So where I was saying your patent agent is trying to basically cover off an idea and give you exclusive ownership of that idea, that's where you're working in the claims language to try and get as broad a scope of invention as possible. Just because I know there's probably some of you who are in the academic environment, either research students or professors, there is a 1-year grace period in Canada and the US from the time you publish a paper, which might disclose that invention that you want to patent. So if you give a talk today, up to a year later, you can still file a patent for that particular invention. And the reason that that's important is that, I probably didn't mention this, is that, well, I guess I did indirectly. When you say that a patent has to be something new, that obviously means that it could not have been publicly available before. So if somebody's written a paper on what you're claiming to have invented 5 years ago, then the patent office is going to pull that out and say, well, you're telling me you want to patent this invention? Well, here's a published paper in the IEEE journal that discloses the same invention. So from your standpoint, if you are in the academic environment where they want to basically, universities want to have as many published papers as possible. So part of this policy is here to allow the publishing of academic papers while at the same time allowing you to still file for a patent. Now, the only other point I'll make on that is that this is only, the 1-year grace period only applies in the US and Canada, so, you may not have that same grace period in other jurisdictions outside of North America, so that's just something to keep in mind, and you probably want to get sort of more detailed advice on that if you're in a situation where you're looking to, publish a paper. Again, the point that I made, patents are territorial. Now, there are all kinds of treaties and processes in place to help to basically allow you to sort of streamline the application process among different jurisdictions. And again, that will depend, again, on your overall business plan. So when you're looking to patent something, and again, this is where I kind of come from, which is from more of a commercial or practical standpoint. If you can get 20, 30, 40, 50 patents in every single country in the world, all the power to you. But the patenting process is very expensive. It's also very time consuming. So really what you're doing is you're trying to look at markets where you're going to be active in. So if you're selling primarily in the States and Germany and Japan, then you're going to look at those markets for pursuing your patent strategy there. And you have to fight to get it. What I mean is that it's having gone to the patent agent or the patent lawyer, having received the advice that yes, probably your invention is patentable, that's not a guarantee that you will in fact have a patent issued, or that you will get a patent issued basically as per your initial application. So you're going to file an application, and your patent agent is going to try and claim everything under the sun. And the patent office is going to come back 6 months or a year later and say, well, this is all great, but these two claims are just way too broad, or this doesn't make sense, or there's another patent that has the same scope in its claims, so we're going to strike this out. And that's where your patent agent basically has to prosecute. They have to go through, it's patent prosecution, which means they have to go through and basically have this back and forth with the patent office to try and get you as broad a scope and to try and get you, the best patent possible. And this process, can take 3, 4, 5 years until the actual patent issues. And hence, be patient, okay? How do you keep a patent? Well, and I may not have mentioned this, but basically for 20 years from the filing date, you get that monopoly over that particular invention that you claim. There's certain maintenance fees that you have to pay after the patent gets issued. You can also file improvement patents to try and extend it beyond those 20 years. And that means that if this is the scope of invention A, if you have improvements on the invention, then you can work with your patent agent to try and extend the life of your patent beyond the 20 years per se. How do you use a patent? Basically it gives you a 20-year monopoly. And what you do then is, having obtained the patent, the idea is that you can exclude your competitors from that particular market. So you can go and sue them, right? Now, again, keep in mind that a patent from an offensive strategy, in the sense that you're trying to exclude competitors, it's only as valuable as your sort of wherewithal to go out and enforce it, because the government is not going to enforce it for you. They will grant you a monopoly, they'll grant you the patent, but it's up to you to get your lawyer, it's up to you to investigate who's doing what in the marketplace, and it's up to you to send the letters and to sue the people who might be infringing on your patent. And sometimes you might be looking to really just license your patent to them, and that might be part of your overall business plan. And if you think about companies like, for example, a lot of biotech companies who are in the initial development stages, really what they end up licensing to the big pharmas who fund them is really a set of patents, essentially, right? Or you look at a company like Qualcomm, which owns all the patents on CDMA technology. Same thing, really their whole business is around licensing of patents. The flip side to that is that you can also use patents as a bargaining chip. So, some companies who may not be looking to basically go out there and enforce their patents or generate licensing revenues from their patents might look at it and say, well, hey, I'm going to build my own little patent portfolio here. And if I get sued by another company, then I can try and see whether perhaps if we're in the same market, they might be infringing on my patent. So we can use this as a sort of a bargaining chip and maybe enter into some sort of cross-licensing agreement. And this may sound odd to you, but in fact, in certain areas, so for example in the software space, there are so many patents out there. And if you speak to a lot of patent agents or people who are in the industry, they will tell you point blank that there's tons of patents out there that are not really, should never have been granted because they're not really claiming anything new. There's algorithms which have been practiced for years and people are claiming patents over them. And secondly, that there's so many patents out there that in fact, most likely everybody's infringing on everybody's patents. So it's a situation where it's kind of like the the Cold War, right? So you got everybody with their arsenal sitting there, and you know, but nobody's really suing. And you know, Microsoft, for example, which was a company, and I mentioned this in my last year's talk, which didn't really actively pursue patents per se. You know, since 2000, 2001, they've just started to patent like everything. I mean, they're like filing as many patents as IBM. And it's funny because people in the software industry started to get scared and they go, okay, well, does this mean Microsoft is going to come after us? Are they going to come after Linux? Are they coming after that? And, you know, really, I think to some extent what Microsoft is doing is they're building up their own sort of arsenal here in case they get into any patent fights, that they have something to sort of fall back on. Venture capital, a lot of VCs, particularly if you're in any space outside of the internet space particularly, they're going to be looking at your patents as proof of the value of your company or the value of your technology. So if you have a letter from a patent agent or you filed a provisional, then they're going to feel a little bit more secure. I have this discussion with VCs all the time as well, and I say, you know, it's going to be about execution. And in fact, if the company doesn't really get anywhere and they don't have any patents, you know, the value of that patent is questionable in any event. But for whatever reason, it gives a lot of VCs a lot of comfort. Now, don't get me wrong, in certain areas, again, for example, with biotech, or if you're looking at something which is, you know, technically complex, where the business plan of the company relies in a big way on, you know, the existence or non-existence of a patent portfolio, then obviously that's going to be a major factor for any investor. So pros and cons of patents. So we talked about, you know, 20-year monopoly, the no good guy defense. What I mean by that is there is no, unlike trade secrets, where if you remember the scenario I described with my client, where they have to go actually and prove that this person in company A was exposed to their technology and now is disclosing it and misusing it in this second company. In a patent scenario, you don't have to prove that this person was disclosed, you know, that you disclosed the technology here, that they took it over, that they misused it. All that you have to prove is that they're doing what your patent claims. It doesn't matter if they never saw your patent, never saw your technology, or that they even independently came up with exactly the same thing. So you file a patent, you obtain a patent, then a year later, they have a brilliant engineer, he comes up with exactly the same thing. It's irrelevant whether they were good guys or bad guys. You still have the ability to enforce your patent and stop them from practicing that invention. Again, I mentioned, you know, it's a business. You can actually, there are companies which build their entire business just on patent portfolios. The cons of patents, and this is where you look at the contrast between a patent and a trade secret, is that with a patent, you basically tell the world what your invention is. So with a trade secret, you're basically selectively disclosing under NDAs, and that's what's giving you it's your secret sauce. Nobody else knows. With a patent, you know, your patent after, you know, 18 months that you file, it becomes publicly available. So anybody can go, you know, on the USPTO or the CIPO website here in Canada and pull up your patent and read the invention and say, hey, that's a great thing. I'm going to go ahead and you know, use this patent and I'm going to implement it in my products. It's up to you to go and enforce your patent. So again, you have to make sure that you're monitoring what other people are doing potentially with your patent and enforcing it and going after those individuals. The cost in terms of patents is also one of the cons, particularly if you're a smaller company. You know, the cost to file an initial application can be anywhere between 2 to 10K. Now, the cost to actually get the patent registered, to prosecute it through the entire, you're looking at least $20,000. And then if you're actually looking to enforce and, you know, read that, I mean, the $1 million is if you actually get into litigation. So that's not really an accurate number. But if you do get into litigation and you're actually, you know, in court and you're doing discoveries and you're bringing technical experts, well, the cost of patent litigation can skyrocket. So the reason I put up this chart is, in particular with respect to patents, is just so that as smaller companies, the one point I'd like to for you to take away is that you should look at your patents as part of your overall business strategy. So don't think that simply because you keep getting patents and you build your patents, then you're done. You have to think, well, what do you want to do with those patents? What's the value? Is a patent valuable for you to get funding? Is a patent valuable because you're building a business that is going to be based on royalties and licensing fees, that you're going to license your patents out? So, keep those things in mind and have that discussion with your patent agent or with your patent lawyer as you're going and thinking through, using patents. So we talked about trade secrets, patents. Third form of intellectual property is copyright. And copyright, basically originates in literary works, right? So books, poetry. But now from a technology standpoint, it's been extended to software, so websites, content, all sorts of content, so musical content, graphics, etc. These are all protected by copyright. It's very important to distinguish copyright from a patent. So the one thing about a copyright is a copyright does not even come close to granting you protection over the idea behind or an invention. Its scope is much more limited. How do you obtain a copyright? Well, basically, if you are the creator, so if a piece of work or a piece of software originates in you and you write it or you created it, then there is immediately on creation copyright attaches to that work. So you don't have to do anything. It's not like a patent. You create it and there's copyright. So it's automatic. The other thing to keep in mind is that it's important because in a startup context where you have employees or contractors who are doing work for you, so they might be contributing content to your website or programming some code for you. Through a written contract, you can basically transfer that copyright over to your business enterprise, and you're sort of building intellectual property and building value in your company. How do you keep copyright? Just be healthy, eat healthy, and exercise, because copyright is tied to the life of the author. So whoever creates the work, it's the life of the author plus 50 years. How do you use it? Basically, copyright still gives you some protection in terms of being able to exclude your competitors, but it only allows you to prevent others from copying what you've created. So it doesn't allow you to stop other people from coming up with the same idea or the same kind of thing if they do it independently. But this copying, or preventing others from copying can apply to any kind of IP where copyright attaches. And of course, licensing it again. So we talked about how you can license trade secrets, same thing with patents, and same thing with copyright. So obviously the whole software business is built around the licensing of copyright and code. The same with the entertainment business or shows, etc. So pros and cons of copyright protection. It's easy and cheap. Why is it easy? Because as you write the code, you have copyright immediately. It's cheap. You don't have to pay anything. You can register your copyright with the Copyright Office in Canada, and it does create a presumption of validity, but essentially, even if you don't file your copyright with the Copyright Office here, you still have copyright protection. So it's cheap. You can capture your employees' contribution through written agreements by transferring copyright in what they create for you, licensing revenue. But as I mentioned, the big con of copyright vis-a-vis patents, and people tend to get confused with this terminology, is that copyright does not protect the idea. Copyright only protects the expression of that particular idea. So, and then the other thing is, there is no, unlike patents, where, as I said, there is no good guy defense, in copyright there is. So if somebody says, listen, I never even saw your code, I have no clue who you are, I was just sitting in my basement and I came up with exactly the same piece of code. If that's a fact, copyright is not going to help you sue that person and prevent them from doing the same thing. So it only protects you against copycats. So there actually has to be an act of copying. So there has to be access to that piece of copyright. Life plus 50, and then monitoring, and I won't get into that in detail, but the point I was trying to make is particularly with prevalence of the internet, the value of copyright, in terms of being able to enforce and enforce your rights when distribution of content is so easy to do. It's just become very difficult, right? And that's why you get into all this digital rights management and the DMCA Act in the States and things that are probably outside the scope of this lecture. But obviously that's a reality that everybody's facing. So we talked about trade secrets, patents, copyright. The last form of IP, we're getting close to the end. Everybody's like, oh God, when is he going to stop? There's more forms of IP. No. Okay, so what is a trademark? A trademark is basically a brand. So brand name, so it could be a company's name, so like, Nike, can be a product like Microsoft Windows, can be a service, anything that you brand and basically distinguish that particular company or product or service in the market, you can protect through trademark protection. As well as design marks. So the famous Nike logo, that would also fall under trademark protection. How do you get a trademark? This is very important. I think people, in terms of trademarks, probably if there's one thing you want to take away from the lecture today is this, is that you have to use the mark in order to obtain trademark rights. So you can, simply by coming up with a mark, doesn't mean you're going to have any rights in that mark. You actually have to use it, and you have to use it in commerce, which means you have to either, if you're providing a service, you have to advertise that service to people under that mark. Or if you have a product, you actually have to sell that product under that mark. So this doesn't necessarily mean that you can't file for a trademark. You can still file for a trademark based on what we call proposed use. So you could, if you're starting your business today and, you want to sell software under the ABC logo, you can file a trademark for ABC based on proposed use, even though the software is not there and it's not yet being sold. But ultimately, for trademark rights to actually exist and attach, you need to use the mark. You have to file an application. It's similar to a patent application, but it's much cheaper, usually much shorter, and much easier to get through. You'd still have to get a trademark search done, depending again, and it's all, again, country by country basis. So, in our office, we work with U.S. Foreign Associates, so they would do the search for us in the States. We do the search in Canada, and we give you an opinion as to whether that mark is potentially available for trademarking. You have to fight for it, so it's still a process. We used to say 12 to 16 months. We've actually, in the last year, we've had trademarks getting registered within 6 months, so I don't know what's happening. Maybe they're becoming more efficient in the Canadian IP office here, but you're looking at least 6 to 8 months usually for it to register. Again, you're going to have some back and forth with the trademark office. Not as complex as the issues with patent prosecution, and not as expensive. We usually estimate about $2,000 in total from start to finish if there's no major complexities in the filing. So having obtained the trademark, how do you keep it? Again, going back to this notion of using it. So you could potentially, through non-use, even if you've used a trademark, let's say for a year, and then you stop using it for a long enough period of time, you could again lose your trademark rights. So continued use is very important, and documenting use. We're actually we have a case with a client where we're actually suing the other side for non-use and seeking to expunge or cancel their trademark so that our client's trademark can go through. And they've produced, as proof of their use, of their early date of use, they've produced some internal sales reports. Now, that doesn't count as use under trademark law. So what you need to do is you have to document a purchase order or some document which actually shows that in fact the product was sold and exchanged hands under that mark. So, I mean, that's just to give you an example. But again, documenting use. So, for example, if you're advertising the services, brochures that have the mark on them. So you want to make sure that you have documentation to back up your use of the mark. Monitoring, similar to patents, you want to monitor potential infringement of your mark. Now, it's a little bit different because, and you probably have the similar concept in patent law as well, but with trademarks, you could, again, because if somebody's out there continuously infringing or using a similar mark, you could, again, lose your rights because you're not enforcing them. So monitoring and enforcement are important things to keep in mind. And then how do you use your trademark? Well, essentially, what a trademark is it protects your reputation. So if there's some reputation or goodwill associated with a particular mark or with your products, the trademark allows you to protect that. You basically use trademarks to avoid confusion in the market. So IBM, if somebody else starts a company, calls it ITM and starts selling computers, what they're really trying to do is they're trying to free ride on IBM's goodwill and reputation that they've created by creating this confusion in the marketplace so that people think that ITM is somehow associated with IBM. And so basically the trademark law allows IBM to prevent that other company from conducting business with a confusing mark. And again, licensing, same way. If you think about it in terms of, for example, in the internet space, like co-branding agreements where there's trademarks being licensed back and forth, or joint trademarks, jointly branded websites with trademarks from various companies. So pros and cons of trademarks. I think we kind of covered this, but again, the one thing I'll leave you with on trademarks is, again, use it or lose it. So you want to make sure that you're continuously using your mark in order to maintain your rights. And that's it. Thank you. Sure.
Under trademark, so you're saying that pretty well any company that wanted to sell under its own name pretty well has to go out there right away and trademark their name. They don't have an automatic presumption. Like for example, if Nike was a small company,
Yes.
another company could just right along and use the exact same name of Nike and sell it.
Good.
Nike has operated.
Right. Well, good question. So I think what I was focusing on was trademarks as registered trademarks with the trademark office. But there are rights at common law through what's called a passing off action. So, and that's why, again, it all goes back to use. So even if Nike, let's say you don't file a trademark, so you're operating as Nike for like 2 years, and somebody else comes up with, Mikey, okay? So, and you haven't registered a trademark. If you've in fact conducted business under the Nike brand for those 2 years, you have certain rights at common law. The difficulty is, first of all, usually those rights are geographically restricted. So for example, if you have a shop in Toronto and you're just selling shoes around the Yonge and Queen area, well, can you then stop somebody in Oshawa who opens up a shop with a Mikey? Because what you really have to prove is that there's some confusion between Mikey and your mark Nike. So if you actually haven't had any use in Oshawa, then you're not going to be able to stop that person. Whereas with a registered trademark, you get protection across Canada, right? So it wouldn't be accurate to say you don't have any rights if you don't register a trademark, but your rights are much more limited. And the other issue that happens is, similarly to patents, where your priority comes from the filing date of the trademark. So if somebody else then comes 6 months later after you've started business, let's say they file for the trademark Nike. Now you get into a very complicated situation where they have priority over you. You can't even file for your trademark now. Now you have to go in and oppose through some other procedures in the trademark office and try and invalidate their mark and say, no, well, I actually had earlier use. So you're kind of, you also leave yourself open for somebody else potentially preventing you from conducting your business. Not only that you can't protect your mark, but it could work against you the other way as well. So, sure.
In terms of use of trademark, you have say a website, you're using a internet advertising. And perhaps there's some revenue associated with that. Is that considered using your trademark?
You know what? It's a little bit of a gray area, but
Could you maybe repeat the question?
yeah, the question was if you're just advertising a product or service on a website, but you're not necessarily selling that product or service, correct? Okay, so it's a little bit, it's not a black or white issue, but the test is for a product, you actually have to have sold the product. So if you just advertise and say, Nike shoes coming, okay, and you want to have the trademark Nike for shoes, if you don't provide those shoes for another 2 years, that's not use, okay? With services, it's a little bit different. So you could, through advertising of a service, it could potentially constitute use, but the services have to be reasonably available to be provided. So again, you can't advertise, just say, I'm advertising the services, and then 5 years later you provide the services. So it's a little bit of more of a gray area for services. Yes?
How do you process licenses? What is the process? How do you, what is legally involved, what's financially involved in licensing? What is the process of licensing?
Okay, so a license is essentially a commercial, sorry, the question was what is involved in a license and what is, legally. A license is essentially a commercial agreement. So basically it's, if there's a software license, for example, so, I own the copyright in certain code, you want to license and use this software in your business, we would enter into an agreement whereby I would say, well, I own all the rights in this code, but I'm granting you permission to use this code in your business for this amount of fees. Now, in every time you buy or you download a piece of software, there's license terms that apply to that software. So a lot of times you'll probably be clicking through. If you go on a website, usually websites will have a link says legal terms or terms of use. They're permitting you through a license agreement that you're not aware of, but you're basically agreeing to through using the website. Or when you buy shrink, or you buy a copy of Microsoft Windows, as part of the shrink wrap, there's some license terms and conditions in there as well. So I don't know if that answered your question.
Yeah, it does. And also regarding licensing patent, you said licensed patent. What do you mean by that? License the product based on patent or license the patent itself?
Okay. Yeah. So the question was, what was I referring to when I said license a patent? No. So what I was referring to is you as the patent owner. So if you filed for a patent or you have a patent that's registered and issued, you may not necessarily want to practice or create products based on that patent yourself. You might have companies out there who have products who could use that technology. So essentially, you're just, by entering into that license agreement, you're not actually giving them anything. All that you're saying is, I will permit you to practice this invention over which I have a monopoly, and you're going to give me X percentage of sales of your product as compensation to me, because otherwise I would have to sue you. So you need my permission in order to practice this invention. So, yes, go ahead.
So in the brave new world of e-commerce, how do you define the scope of your trademark protection, and how would you enforce it? So for instance, eBay, it mostly runs out of North America. They have one in Japan, and let's say someone in Kazakhstan came up with eBay. Can you protect it? And where would you go to protect that, right?
So the question was, I guess, given the nature of the internet and how broad it is and usage of marks, how do you enforce it? Well, I can't really comment on Kazakhstan or some jurisdiction like that, obviously, but I think, again, the question comes back to usage of the mark, right? So has the mark been used in that particular jurisdiction? And with the internet, because you have users accessing the site through different kinds, different locations, it's not really location specific, then even if you don't have necessarily a registered trademark in that jurisdiction, you could still make the claim that the trademark is known and that it's in fact been used in that jurisdiction, right? So I think it becomes probably the internet helps in that regard. I think the question is more difficult where you're operating more of a local business, right? And then you want to expand into a new market, and there's somebody else in that market who's already been using that mark, let's say, right? That becomes more of a difficult issue because you actually have had no presence in that market whatsoever, and you can't really establish prior use. So I think that, it's probably the, yeah.
In the case of a trade secret, that is a chemical formula, if you need to disclose for regulatory purposes such as MSDS, do you have any way to protect yourself?
So can you explain that? I mean, I've never come across this.
Say, for example, you create a formula that contains some secret chemicals or non-secret chemicals. How would you, if you need to send it somewhere or provide it in the workplace, you need to provide a material safety sheet?
Right.
It has to be a government regulation.
Uh-huh.
Is there a way you can register your trade secret? And how do you go about
Yeah, so I think that the question, if I may rephrase, is that in the case of chemical compounds, if you have to disclose a formula which you consider to be a trade secret for regulatory approval, how do you deal with that, right? So, okay, so I guess the first point, there's no registration of trade secrets, but I guess I personally haven't had experience with the point that you're raising, but I guess the question is, from a trade secret law perspective, is if you disclose this to the regulatory agency, do they then post it up and make it publicly available, or do they just use it for the purpose of approving your particular compound?
in the case if you actually engage in commerce of a chemical substance?
Yeah,
You need to provide, whoever you sell it to, give it to, a material safety data sheet.
correct.
That describes the properties of the material.
Actually, let me field that
Sure.
one, because I've actually had some experience, and you're absolutely right. Many companies will not buy a product unless it's accompanied
By material safety.
Yeah, it's a standard form material safety.
Right,
data
right.
sheet. But if you look at commercial material safety data sheets, they're pretty vague. You don't have to put down a chemical formula, okay? Because, I've tried to look at it or learn something about competitors' products, and I've been uniformly disappointed about how little information. This gives cold comfort to people who are relying on these. So, you have to disclose, potential hazards, and be very honest and clear about that. But I'm not aware that you have to give a detailed formula. You can say, an ethylenic polymer. So, I'm certainly not an expert on that. That's something, if this is crucial to your business, I would get professional advice. But again, my experience with MSDS is they are remarkably uninformative about what's actually in the damn thing. They had good words.
Yeah.
How can you effectively license a pending patent?
The question is, how can you effectively license a pending patent? I actually had somebody approach me about a year ago, just on that point, and they were trying to get a fairly large company to license this pending patent. Hey, if you can get a big company to license a pending patent, all the power to you, right? Because they're basically taking the risk of what am I getting here, right? I mean, is the patent ever going to issue? So really, because there's always a risk of that the patent is not really going to go through, right? So you may have just filed it, and then you get into this discussion. So the answer is really you want to be in a situation where you have a registered patent, and that's where you really can, if you're trying to get into a serious negotiation with a licensee.
Just regarding the patents, usually you have your patent in a method and sometimes a configuration, an instrument, and there is software involved in that. Do you include that software in the patent, or do you have to put it separately as copyright? What do you do in such a case?
Okay, so the question was if you have an invention which is some sort of equipment or something that includes some software, do you have to patent the software separately, or can you do it as part of the whole thing? I'm a bit tentative to answer that in the abstract because it's really going to depend on your particular invention. I guess I'm assuming the reason you're asking this question is because you understand that software can't be patented. Is that okay? So yeah, I mean in the States you basically you can go ahead and patent software. Even in Canada there are ways to patent software. I think you really have to look at your particular invention to see how you actually phrase it, whether you do a separate process patent and a separate machine patent, or do you just do a machine patent? It's really going to depend on the nature of your invention and how much value the software adds to it and how it fits in. But in terms of your other question, the software will always be automatically copyrighted. So you don't have to worry about copyright protection. I mean, if you've written the code, it's copyrighted. The problem is the thought process you want to go through is, well, if somebody recreates, is there something that's so innovative in the software or the algorithm that I would want to avoid anybody else basically implementing this algorithm, even if they come up with it on their own? So even if they're not copying my code, I don't want anybody to be able to recreate this algorithm. So I want to patent the algorithm. So not the copyright in the code, which would basically prevent people from copying your code, but the actual algorithm or the process that you're implementing, is that so innovative that you want to stop anybody else from doing that? That's the thought process you want to go through on that.
Assuming I've created a software content or a creation tool, content management, knowledge management tool, I will now need content to fill that. There are probably three extremes. On the one extreme could be the Wikipedia model, which is totally free content with no copyright other than what's inherently in it. And then there's maybe the Britannica model where they own everything as part of their company, as part of their work. And then there's maybe the kind of middle ground, which is what Apple and iPhone developers are doing right now as an iPhone. I get 70% of what I post up there versus free. In your experience and in the marketplace right now, and from a venture capitalist's exit strategy point of view, what would be the best choice there in terms of acquiring and using content?
So the question was, I guess. Sorry, I'm gonna paraphrase, but I think the question was in terms of content ownership and models of content ownership or content aggregation, that where traditionally we may have been looking at, I got to own all the content 100%, versus, well, there's content that's getting distributed or contributed from different people. Where does this lie in terms of the VC community and where you'd want to sit on the spectrum? Is that kind of...
How much would I invest, therefore, in copyright efforts accordingly to make
Okay.
a better company?
So I'm not exactly sure if I understand your question, but I think, let me try and answer it. I think from a content standpoint, what's happened is with the advent of the internet, there's very few sites out there where you go on the website and all the content is owned by that company, right? The vast majority on the content on that company is going to be licensed in. So even if you go, so let's say for example, in most cases, if you go on a forum on a website and you make comments or you put a posting on a website, most of the terms of use of the internet companies are not going to basically assume ownership of your content or your posting or what you put in the forum. In most cases, they're just asking for a license from you. So you're still the owner of the code. So in my experience, that's never stopped a VC from investing in that kind of a company. But the important thing from the VC standpoint is, what is the nature of that content? What can they do with that content going forward, right? So rather than, do they 100% own everything, right? And so, it really is going to depend on your business model, your business plan, what types of content are we talking about, and what do you want to do with the content. So it's kind of hard to answer it in the abstract.
I'd add to that, as knowing very little about the space, but as a VC, I would simply look at it and say, okay, you go, model of getting product to customers. So revenue equals the quantity of product times the fraction that I get from the sale of each product. If that fraction is very high, then the number of people bringing product in is going to be relatively small. Likewise, if my fraction is very small, I'll get lots of people bringing content in. So somewhere in there, there's a function, and it's a curve. It's a bell curve.
Yeah.
So what I'm going to look to you is to say, what do you know about the market that's going to get the maximum?
Right.
That's the balance, the trade-off there. So I'm basically going to look at your business model, and I'm going to say, yes, it's a good model. How do we maximize the return? And it's not going to be probably at the low end or at the high end. It's some function, and I'm going to push back on you. Say, what do you understand about the marketplace that motivates people to put product there? What are their alternatives for selling? And I'm thinking of the iTunes model. You know, they could sell albums, but that isn't working. So, they have to see that, again, sharing the pie. You have to they have to get enough to make it better for them than the alternative. So it all depends on, I would say, on the business model.
Yeah, yeah. And just to follow up on and to agree with Tony's thoughts, it also is going to depend on what you can get away with, right? I mean, so the developer model, the developers, are, a lot of them don't like, they're not going to give up ownership of their code, right? So a lot of them are going to say, well, I want to reuse this somewhere else. I'm just going to license to you for your platform, but I don't want it to stop me from, licensing this somewhere else, right? Same thing with a lot of content contributors. So people, freelancers, guest writers on these websites. A lot of these websites you go to, it's not like they have 100 staff writers who are writing articles. A lot of these are freelancers that are contributing content. They're not owning the content from those freelancers, right? So a lot of times they're taking license. So, but it's going to depend on what, as Tony said, what's the split and how do you maximize in terms of your model? How do you get the most revenue, right, and maximize that? So.
VCs won't look at that business model as a whole of having acquired content, let's say through licensing. They won't look at that and say, well, you don't own any.
No, but I guess, no, that in and of itself is not going to negate your business model. But the question is, are you just 100% a content aggregator, or do you have any other technology or content that is your own as well to support that, or is it 100% based on incoming content? I don't know, but I think, I can tell you, there's a client of mine who's been through several rounds of venture capital, and they have, in fact, a large piece of their portion of their content is precisely that, is in license.
VCs are very simple.
Yeah,
These
so.
are the sustainable revenue producing model.
Yeah.
That's the only question. If you don't have to own it, but you're convincing that you can make money now and sustain that, then
yeah. And I think just another, the other thing you got to look at, and we're probably getting to too much details here, but when you talk about, well, we're not going to own it, we're going to license it, and this is what I do, half of my time is spent on this, is, well, what does license it mean? Because that licensing agreement can be an excellent licensing agreement, or it can be a very badly drafted licensing agreement. What are the rights that you're taking on? Can you pass those? What is the scope of the license, right? Is it exclusive? Are you the only one who can use it in the online space, or could they go set up another site? And so there's a little bit of nuance in terms of what is the nature of what is your licensing model, right? That's the other thing that the VCs will certainly look at. So, okay, so you don't own it. We're not opposed to licensing, but what's your licensing model? What rights are you getting? What's the revenue split, et cetera? So, oh, that's a good question. Oh, that's a very complicated question. So on a patent, you'll see there might be the patentees who are the inventors, and then you'll have the owners. I think you're talking about a situation where there's joint owners. So, the inventees. In that case, if you work at a company, for example, so there might be 3 employees who contributed to an invention, and a lot of big companies will pay them a bonus or something for the number of patents they file. But the owner of the patent per se is going to be the company. So the inventees are just part of, I mean, they're listed, but the actual owner, the person who can actually exercise all the rights as the patent holder, is the company that is the owner of the patent, right? Not the inventees. Well, if you have joint owners, then you get into complicated situation, because then you got to think about, well, what can each of, and there's complex laws in terms of, what each owner can do. Can they go off and license the invention on their own, or do they need to get the consent of the other joint owner? If they license it on their own, do they then have to divvy up whatever profits they get 50-50 between the two joint owners? So joint ownership is a very complex thing. And I think, not only in terms of patents, but in terms of other kinds of intellectual property, one of the issues I see a lot of times is with clients, before they engage a lawyer, they will sign these agreements, and these agreements will say, such and such people are like, joint owners of whatever technology comes out. And that stuff is like, that is the worst kind of scenario you can have as a lawyer, because the significance of that, first of all, a lot of times it's very dubious what it means. It's not really drafted properly. But even if they were joint owners, it creates tons of problems. So I always usually recommend against any sort of joint ownership in agreements. And, or sometimes I'll see agreements that I'll say, 35% is going to be owned by this person and 35% by that person. And so, but from a legal standpoint, you can't really divvy up IP like that. So I think joint ownership is something that you probably want to stay away from. Or if you're trying to sort of bring everybody in the game, then try and get some legal advice so you can put that out and carve that out properly. So should we take any more questions? One last question maybe? Yeah, go ahead.
You mentioned that medical procedures are not patentable in Canada.
Yeah.
Do you mean surgical procedures? I mean, what's the scope of this?
Okay, so what I'm talking about is a medical treatment. So for example, things like diagnostic equipment, for example, which is used in for medical applications, that is patentable. So.
A device that's used for treatment or diagnostics or prognosis, these are all patentable?
For prognosis, but maybe not for treatment. So it's really more of its methods of medical treatment versus diagnostics or things like that. So
Used for treatment.
a priori, it's not patentable, right? Yeah. Okay. All right. Thank you.
Thank you.
Thank you very much.